Good afternoon. Is everybody ready to rock? Welcome, and delighted to have the Attorney General here. As many of you might have heard, today Entergy sued the state of Vermont in the U.S. District Court. Entergy's lawsuit claims that Vermont should have no role in approving Vermont Yankees' future after 2012 in the state of Vermont. As governor, as you know, I've taken the oath to uphold and protect the laws of the state of Vermont, and I want to assure Vermonters that that's exactly what I will do as your governor. Fortunately, we have been ready for this event. The Attorney General and his team have been working hard in the eventuality that Entergy Louisiana might choose to sue the state of Vermont, and we're prepared to defend Vermonters and to uphold the laws of the state of Vermont. I just want to remind you that when I was a young person, Vermont Yankee was proposed to Vermonters, and it was required that the Vermont legislature back in the 1970s vote affirmatively to build the plant in order for Vermont to allow a nuclear plant to be built in the Green Mountain State. The legislature voted to do so, and when they voted, they gave permission to have a nuclear power plant in Vermont until March of 2012. My predecessor, Governor Jim Douglas, along with the legislature, passed a bill that required Entergy Louisiana or any other operator to have a similar vote from the Vermont legislature in order to operate beyond 2012. I want to make the point that I was not in the legislature at that time, but Governor Douglas and the legislature felt it was important that Vermonters should weigh in on the future of the plant after 2012, just like they've been asked to make the judgment of whether it was appropriate or not to have a plant in the state up until 2012. I want to remind you that at the time, Entergy Louisiana enthusiastically supported the bill that was signed by Governor Douglas. I should also remind you that when Entergy Louisiana bought the plant, they signed a memorandum of understanding that they would comply with all Vermont laws. We fully expect that Entergy Louisiana should be held to the same standard as any other Vermonter. You must follow our laws. As governor, I will see to it that Entergy Louisiana does follow our laws. I'm happy to turn it over to our able Attorney General, Bill Sorrell, who's been preparing for this case.
Thank you, Governor. Filing of this lawsuit today is a disappointment, but no surprise whatsoever. We've known for at least months that we were going to end up in court. We actually wished that and thought that Entergy would have filed sooner. They waited till today, and the battle is joined. We've been spending months getting ready for this lawsuit. We're pleased that it's being litigated in federal court here in Vermont, and we look forward to aggressively defending Vermont law. We wish that Entergy had more respect for the laws of this state. We also wish that Entergy would abide by the agreements that it has made in the past, and that it would act in accordance with statements reported all over the media over the years of their recognition of Vermont law, their requirement that they get the approval of the Vermont legislature and the Public Service Board to continue operating beyond March of next year. We look forward to being before the federal judge and defending the law and demonstrating that the conduct of Vermont Yankee by filing this lawsuit is inconsistent with their statements and their agreements in the past. The nature of this case at the district court level is one that, since they're seeking injunctive relief, and we anticipate another filing by Entergy perhaps within a matter of days, seeking an injunction to essentially prevent us from enforcing our law as of March of 2012. The nature of this case is one that obviously the judge will decide through the scheduling, but that we would look to get a decision at the district court level sometime between perhaps as early as late spring to sometime maybe in the mid to late fall of this year. Assuming one of you would ask a question to this effect, I can't imagine that this case is going to be resolved at the district court level here in Vermont, and that's going to be the end of it. Perhaps, but I think it's entirely likely that this is a case that will be appealed by one party or the other to the Federal Appeals Court in New York City, and conceivably beyond that. So, although we could get an initial read on the case in the relatively near future, it's entirely possible that this case will be litigated for quite some long time into the future. But we've been ready, we are ready, the battle's been joined, and we're ready to go.
Thank you, Attorney General. I'll be happy to answer any questions if you have them.
Did you think
sorry.
Did you think it might be filed elsewhere? Was that, you said we're glad to have it in Vermont. Was that a possibility? Was this bode better somehow?
Oh, well, it's obviously more convenient for us, and as they reflected in the complaint, that the parties are largely here, the plant is here, we're talking about Vermont law, but it's entirely possible that it could have been filed in another court. This is certainly convenient for us.
What about the constitutional issues that Entergy raised this morning, Bill? Are those really secondary to the issue of the state law, or do you worry about that aspect of their argument?
Well, anytime a constitutional violation is alleged, that's hugely important, and Vermont law cannot violate the federal constitution. So we were mindful of the federal constitution and the state constitution when the legislature adopted the law. Certainly a presumed constitutionality there, and so no, we need to defend the constitutional claims also, for sure.
Is that part of it? Is that a primary argument that they're making, or is that really secondary?
I'd leave it to them to define the strengths and weaknesses of their particular arguments, in which they say are primary and which are secondary. I'll say this, there's virtually nothing in this complaint that surprises us. They've thrown everything but the kitchen sink in here, and we're going to defend on all bases.
What about this assertion that state officials have made threatening comments that they wouldn't get the CPG unless they agree to provide below market rate power to Vermont utilities?
Let them prove that in court.
Governor, they're claiming that we changed the rules on them, that in 2002 they agreed to come in and seek permission from the Public Service Board. Subsequently, we said we put the legislature there. Do you see it that way, that we've added a different layer of political decision-making here?
You know, I want to remind you that I wasn't here at the time, so let's put it in their words, if we could. Let's let them ask the question. In the 5/21/2006 Rutland Herald article, Douglas signs bill giving lawmakers say on nuke's future. It reads as follows, quote, Vermont Yankee spokesman Robert Williams said officials at the plant like the law, in part because it sets up a process that isn't overly complicated. Quote, we commend the legislature, especially the House Natural Resources and Energy Committee, for putting a lot of effort into drafting a bill that would serve the state well, he said. They recognize the importance of fully addressing the question of Vermont's future energy supplies. So I think Rob Williams answered the question in that press clip. There are many others like it. I mean, the point of the matter is that Entergy Louisiana, as I have said before, does not do business the way we do business in Vermont. We keep our word. We tell the truth. We follow the laws of the state. Entergy has struggled to do that. How can you complain about a law in federal court that you supported when it passed and was signed by Governor James Douglas? It just puzzles me.
The question is, are they trying to have it both ways? They came to the state wanting to make agreements to buy the plant initially and then to be able to store their spent fuels. And that leads to the conclusion, or at least the observation, that they're trying to have it both ways. They made the agreements when it was to their advantage to make the agreements so they could buy the plant and operate, and now they're saying, whoops, 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 not a good deal for us, illegal, never should have done it, state can't enforce it. So we'll see.
Governor, how, as the top elected official in the state of Vermont, how do you feel being in this situation with Entergy Louisiana?
Well, I mean, obviously, we would prefer if companies doing business in Vermont would follow the law, particularly when they supported the laws as they were signed into law that they now claim or wish they hadn't. So, long and short of it is, as governor, I've got to be prepared for any development. This one doesn't come as an extraordinary surprise from a company like Entergy Louisiana. But I'm glad that we have an extraordinarily capable attorney general and a team of lawyers to defend Vermont, and I'm sure that the judges will see to it that Vermont law is upheld.
Is it inevitable the plant's going to stay open beyond March 2012 because of this litigation and what it may lead to?
Absolutely not. I believe that the plant will be closed in March 2012 as Vermont law has directed, and that the company will abide by that law.
Bill, didn't you just indicate otherwise, that you would expect this lawsuit to go, and you would expect them to try for an
I expect the
injunction?
lawsuit to potentially go on for a long time. That is not at all inconsistent with what the governor has just said. We're going to fight very hard to have the plant stop operations in late March of next year. And we hope to have a decision from the U.S. District Court that's favorable to us against the requested injunctive relief by Entergy, and that during what might be a lengthy appeals process, that the plant would remain closed.
Isn't there the possibility, though, that it could stay open for years on end if there isn't a decision by the district court? I mean, how would you close it? Would you send national troops in?
It is entirely possible that if they prevail at the district court level, or on the injunctive relief issue, or on other issues on the merits, or as a result of a decision by the intermediate appeals court, that they could stay open. We're going to fight very hard to have that not be the case. But that's going to be a decision for the federal judiciary to make.
Is there any room to negotiate here? They talk about that they were in negotiations, particularly on the decommissioning question, that they had agreed to accelerate the period of safe store, but that those talks broke down and they have to file suit. But is there any room to go back to the negotiations and try and resolve this without a court fight?
We are where we are, and I just want to point out that we have not been in negotiations with Entergy Louisiana at any time, in any shape or any form. The negotiations that happened were under Vermont law, where Entergy Louisiana and the power companies, Green Mountain Power and CV, were supposed to negotiate a purchase price agreement, PPA, and come to the legislature with that PPA. I think it's significant that Green Mountain Power and CV tried valiantly to come to an agreement with Entergy Louisiana and couldn't, and were quite frustrated by the fact that they couldn't. So, again, Entergy's claims don't seem to match up with the facts.